That's right. Things are getting a little weird there in Delphi. So Judge Gull, who is overseeing the proceedings for Richard Allen, the man accused in the Delphi murders, has thrown out a filing made by the former attorneys for Richard Allen, a guy by the name of Bradley Rozzi, that argued that the judge should be removed from the Delphi murder case due to claims that the judge pressured the defense attorneys to withdraw from the case last week. Now, the move comes after a flurry of exchanges between the former defense attorney and the Allen County judge following a somewhat a little surprising hearing last week that ended with Judge Gull announcing that both of Allen's defense attorneys would be withdrawing from the case. Now, Mr. Rozzi argued that Richard Allen, the man accused of killing Abby Williams and Libby German outside of Delphi there in Indiana back in 2017, never signed off on this whole issue regarding the change of counsel. And at last Friday's hearing, the judge announced that Allen's other defense attorney, Andrew Baldwin, was voluntarily withdrawing from the case and said Rozzi would be following Baldwin's lead and withdrawing in the upcoming days. The withdrawal came on the heels of an alleged evidence leak traced back to Mr. Baldwin. Now, Allen's other defense attorney, Andrew Baldwin, claimed he was snookered and betrayed by a former employee who had unauthorized access to the Delphi evidence in Baldwin's office and leaked the evidence to a Facebook page regarding the Delphi followers of the case. Now, in this somewhat surprising turn, Rozzi filed a motion calling Judge Gull to be recused from the case after suddenly backpedaling on the previous story of his impending withdrawal from the case, and instead stated he did not want to withdraw from the case and wished for Gull to be thrown off the murder trial. Now, we brought you this motion last week. We read it verbatim. Somewhat interesting. The allegations were made that he was basically pressured by the judge to do so. Now, however, the court, Judge Gull, has ordered that that motion be stricken from the record. And in another order by Judge Gull, the judge said that Rozzi was withdrawn from the Delphi case as of October 19th and therefore was no longer legal counsel of record for Mr. Allen, and therefore his filings mean nothing and they will be stricken from the record. In fact, the court went on to note that since Rozzi is no longer even considered legally a part of the case filing should never have been accepted. The judge is not wrong there. No attorney can just simply file motions in a particular case, and if they've withdrawn, they need permission to enter the case. And when the judge says you're off, when it's a court-appointed matter, you're off. Unless you want to hire or enter the case as a private attorney, if you've been retained to do so, only then would you be allowed to re-enter the case and have any of your pleadings heard in any way. So let's bring in another attorney. This attorney's name is David Hennessy. He is an attorney representing Rozzi and Baldwin and recently argued against Gull and claimed that she strong-armed the attorneys into offering oral withdrawals from the case and contends Gull doesn't have the authority to direct the clerk to strip Baldwin and Rozzi's name from the court docket without a file notice of withdrawal or a valid written motion. Hennessy will apparently be filing a motion to reconsider that he intends to file as early as this week in response to Gull's order of having the defense attorneys removed from the case. Now, having new attorneys assigned and having Rozzi's request for the judge to recuse herself stricken from the record. We'll see how that works. In the soon-to-be-filed motion, Mr. Hennessy apparently calls on the court to reconsider the erroneous order to the clerk of the court and the removal of the appointed counsel without the opportunity to be heard. No judge has the authority to oversee the clerk or order the clerk to alter the record of the court filings, according to Mr. Hennessy. We'll see how this is playing out. It gets a little weird. Now, Mr. Hennessy continues to allege that Baldwin's oral motion to withdraw from the case on October 19th is a nullity and invalid due to Baldwin never filing a written motion to withdraw. Now, I'm not sure exactly how things are done in Indiana, but I have made oral motions to withdraw that have been granted on the record. So I'm not sure why they're getting so hung up on this particular issue. What it boils down to is the judge appointed them and the judge took the case away from them. Mr. Hennessy's motion also cites state law in contending that the judge loses the authority and jurisdiction to make rulings on other court motions or issues and orders other than a hearing upon the filing of the motion for recusal and to disqualify the motion filed on behalf of Rozzi just days in which Gull ordered stricken from the record. Now, 2 new attorneys have been appointed to represent Richard Allen. Friday, the court appointed attorney Robert Screamin, Scremin, and attorney William Labrato, Lebrato, as contract public defenders in Mr. Allen's case. Both Screamin and Labrato are defense attorneys based in Fort Wayne, Indiana. There's also a hearing scheduled for tomorrow, and we'll see if this issue is brought to light. But my thinking is the old attorneys are out, the new attorneys are in, and they can begin anew. And the question now is, will they follow the same theory of defense that the previous defense counsels did? We'll have to wait and see. Let me know what you think. Are Mr. Allen's attorneys, former attorneys, being railroaded? Was it really because of a security breach? Or maybe they're getting close to the truth? Let me know in the comments below. Bryan Kohberger gets a win over the prosecution. Now, when I say win, the defense won a motion. And if you were to go back and look at our previous episodes when we talked about the defense wanting what they get in this particular case, I said, give it to them. And I told you, my old boss in the military was always, I'll give the defense whatever they want, and we're still going to win. I don't understand why the prosecution was hiding this. All the IGG information is going to be turned over to the judge. The judge is going to look at it, see what's relevant, decide what the defense gets. That's all. And the judge is saying, hey, you know, the defense has made a couple of good arguments here. One, it's certainly in the care, custody, and control of the state, so they should have turned it over. Why were you delaying it? And to make kind of a frivolous argument, well, the FBI is not within our control. We're just a little old prosecution office here. They were involved in the investigation. They have to turn it over. It makes you wonder why they don't want to do it and why they haven't done it to this point. This is why I don't get it. The government just needs to turn everything over. I've said it before. It creates doubt. It creates speculation of something nefarious going on. And finally, the judge says, hey, the way this is all created may change all these statistical numbers that the state's throwing around that, man, you know, Bryan Kohberger is 5.37 octillion times the guy than just some excluded guy walking down the street. So, or some random guy going down the street, I should say. So that's what it is. Is it a win for Bryan Kohberger? Yes, because the prosecution didn't get their way. Shows the judge being completely fair, very intellectually honest in his analysis and his opinion. Does it mean it's coming in at trial? Not necessarily, unless the defense is going to be able to show, hey, you know what? Bryan Kohberger has this brother that was unbeknownst to him that lived in the same area that drives a very similar car. That his DNA could be the fact of on the knife sheath button. Kind of a stretch, but the defense is at least allowed to explore that possibility. And guess what? If the experts for the defense go through this and find there's nothing there, we're never going to hear from these experts again. That's called the truth-seeking process, ladies and gentlemen. And we need it. It's good. And it protects everybody. The Delphi case. Well, as you know, the judge in the Delphi case had kicked off the previous attorneys that were representing Mr. Allen in that case. He's obviously accused of killing Libby German and Abby Williams. So how did all this happen? Well, remember the defense filed a motion that they said the prosecution and the police were basically not doing their jobs. They overlooked the killing of the satanic cult, basically, and therefore dismissed the case, and that there were lies in the statements, and therefore the affidavits were false information and therefore should be released. Well, then there was now accusation that crime scene photos had been leaked from the defense attorney's offices. Well, there was supposed to be a hearing last week. The attorneys show up, Andrew Baldwin and Brad, Rozzi. I guess he pronounces it Rossi, even though it's a Z. Really. Anyway, the judge ordered them off the case, basically gave them the option of withdrawing or I'm going to kick you off the case. They chose to withdraw. Well, then earlier, late last week, early this week, they filed motions with the Indiana Supreme Court saying, You can't kick me off, Judge. What you're doing is illegal, and you're striking all of our pleadings. You can't do that. We'll see what happens in the Supreme Court, but there was going to be a hearing, and it was actually held yesterday. And what happens? So the attorneys show up, Baldwin and Rossi, saying that they're going to represent Mr. Allen, and they're going to do it for free. The judge said, not on my watch. The judge said that Baldwin and Rossi were removed from the case because of the leak evidence, that it was a gross deviance, basically malpractice, violation of the court's orders, and they are off the case. So the court has now ordered that defense attorney William Labrado and Richard Sermon are the new appointed attorneys for Mr. Allen's case. Now, this gets really interesting. If the attorneys violated the court order, they should be held in contempt. That's what takes place. I have never seen an attorney, let alone two attorneys, on a very serious capital case whereby they're removed for alleged misconduct, but there's no grievances at the bar saying that they should be disbarred or some sort of sanctions. Maybe that's forthcoming. Never seen anything like it. And remember, this raises all kinds of weird issues. Yes, Mr. Allen is entitled to counsel, not necessarily counsel of his choosing, but in this particular case, the attorneys are willing to do it pro bono. That's free. Now, my advice to them would be run. You got off of the case. This case will bankrupt you to defend. And more likely, if Mr. Allen's convicted, he's going to say you didn't have the resources to effectively do it, and you prejudiced my defense. But when a defendant says, no, I want that attorney, and he's willing to do it for free, it really gets into Sixth Amendment counsel of choice issues. I don't know why the court wants to make these appellate issues when they didn't need to exist. Now, the prosecution basically says that the attorneys for Mr. Allen lied. And that's another reason why they should be off the case. Well, if you think what they put in their motions were lies, then let us see why that is untruthful or not supported by the facts in the particular case. It's very odd to me. And yes, when there's a protective order, attorneys have to protect the information. If somebody takes it from your office without your knowledge, well, maybe you should have done better protecting it. But to kick you off your case, it's very odd to me. And I somehow have a feeling there may be something else there, but I just don't know what quite yet. But just remember, very unusual. And needless to say, the trial date is not going to be set until October 15th of 2024. Why? Because the new attorneys need to get up to speed. So literally another year in the making. Be curious to see if the new attorneys adopt the motions of the old attorneys, or if they think that the theory of the previous attorneys was just complete hogwash. Next on the docket, the yoga teacher murder trial. That's right. The trial got underway this week as both sides laid out opening arguments before the jury, with the prosecutors alleging that Caitlin Armstrong stood over Mariah Mo Wilson and shot her in the heart in an explosive beginning of the case. Now, Armstrong appeared in court with seemingly dyed hair after she previously dyed it darker color and underwent plastic surgery while on the run last year. Now, prosecutors grew enraged and raised objections as Armstrong's attorney went through their remarks, who said they would focus on reason, doubt, and common sense. The yoga instructor's lawyers said she fled from Austin to New York and then ultimately Costa Rica after police questioned her because she was, passionate about traveling and yoga. Oh, yeah, and maybe also the key suspect in a homicide case of the girlfriend that was dating your boyfriend. Yeah, I mean, come on. Sure, got to go pursue that yoga. Let me get my nose job done as well and change the color of my hair and hide out in Costa Rica. Seems completely plausible. Well, anyway, they argued that Armstrong started fearing for her safety after some weird things happened to her, but claimed she was unaware the police were actually searching for her. Now, prosecutors countered that Miss Armstrong Googled herself while in Costa Rica. And in their opening statements, prosecutors said the last thing that Mo did on this earth was to scream, and you're going to hear those screams. There's a surveillance camera with an audio coursing through it. The prosecutor said, we'll play it for you. You'll hear those screams. You'll also hear pam, 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 the prosecutor said, clapping to mimic the sound of the gunshot. Now, Caitlin Armstrong stood over Mo Wilson and put a third shot right in Mo's heart. the prosecutors allege. And it was also revealed that 2 of the 3 shell casings from the shooting were quickly located, before the third was later found lodged in a tile floor where Wilson had been laying. The casings, prosecutors allege, were a match to the 9mm Sig Sauer handgun owned by Miss Armstrong. The prosecutors allege that they also planned to present testimony from Strickland about his romance, that's the boyfriend, the romance with Armstrong and his friendship with Miss Wilson. Now, Strickland went into hiding after the murder when Armstrong was on the run and had allegedly hidden his previous fling with Wilson from her. It's going to be an interesting one. I'm a little disappointed that the judge is only allowing the opening and closing statements and not the actual evidence. What do these courts have a problem with letting the world see what you could go walk into their courtroom? Let the world see how the process is working.